Let's bring in Brian Claypool to try and figure out why the jury could not come to a unanimous decision with respect to Jane Doe number 4. Brian, the split for Jane Doe number 4, count 7, the forcible rape was 10-2 in favor of guilt. And with count 8, rape of an unconscious person, the split was 8-4 in favor of guilt. Okay, so I spoke to Mark Carlos and Brian Watkins a little earlier, and my big question was, and a lot of people share this question, was what happened to Matt Vaughn and Chris Resto? Matt Vaughn was on the defense's witness list. Matt Vaughn was allegedly also with Kellen Winslow during this allegation of sexual assault that Jane Doe number 4 complained of. So let's just take a listen to what Mark Carlos said about why Matt Vaughn and another potential witness to the incident, Chris Resto, did not testify for the defense.
They were not interviewed by law enforcement, so they knew who they were. They didn't go out and interview them. They have, as you can probably tell, they have a right against self-incrimination. If Jane Doe 4's testimony alone was enough to levy a charge against Kellen Winslow, clearly her testimony alone would be enough to levy a charge against them, so against at least Matt Vaughn. So whether or not he has an attorney right now, we don't know. There are factors that come into play as to whether or not he can be called. I mean, like I said, he has a right to talk to a lawyer. But, we have to put people on our witness list because we don't want to be precluded from calling them. If we don't put them on a witness list, then we can't call them.
Brian, what was the hang-up with Jane Doe number 4? Was it in part because we didn't hear from Matt Vaughn and Chris Resto? And clearly, if Matt Vaughn was alleged to have been involved in the incident but testified for the defense, he almost would have been endorsing Kellen Winslow's innocence.
Right. That's a fascinating part about the 10-2 vote on Jane Doe number 4 and the 8-4. Because when this trial first started, I thought exactly what you did. I said, where's Matt? Where's this guy Matt? He's going to come in and he'll seal the deal one way or the other, right? And if he's buddies with Kellen Winslow, then I would have expected him to come in and mirror Kellen Winslow II's version. So he didn't testify. But to Mark Carlos's defense, he might not have control over that witness. He's not representing Matt. Matt might have a lawyer. Matt might be difficult. Matt might walk into a courtroom and who knows what. If Matt came in and pled the 5th, what do you think a jury would do with that, right? They're going to think, oh my gosh, something bad happened, and then they're going to impute that to Kellen Winslow II. So I think that was a good decision to not bring him in if he's not controlled. But I think the real reason why the jury didn't come up with a conviction on 4, and remember, I have to admit, I thought Jane Doe number 4 was the best chance at getting a conviction. I was surprised that it was Jane Doe 2, but I think with Jane Doe number 4, remember that time when she talked about it happening in a car?
Right.
And then she even admitted, and I know it, and she even admitted too. Remember, I thought Carlos or Watkins did a good job of getting her to admit that she contributed. Remember that?
Yes.
They asked her, didn't you contribute to the situation getting to where it was? And I thought those were two real game changers for the defense to justify why at least 2 to 4 jurors would not find a conviction on that one.
So, okay, we're still Jane Doe number 4. Part of the decision on Jane Doe number 4, the defense actually made an argument that this is why the deliberation should not have continued. Okay, so yesterday they got the note. They've only decided on 4 out of 12 charges. Then it was the deadlock note. And Carlos said, let's stay with the deadlock. Let's end this trial. Today, the defense comes in with a motion to dismiss. And in essence, they're saying the guilty charge for Jane Doe number 2, that charge in the verdict form, they found guilt for that count, rape by force or fear, but they said not true for the specification that basically says, hey, there wasn't more than one victim. So the defense is saying, if there wasn't more than one victim, we cannot deliberate on Jane Doe number 1 and Jane Doe number 4. Let's listen to a bit of sound. Brian Watkins discussing this.
There's the difference between our case and the Carbajal case. So in the Carbajal case, they found the allegation to be true, so that is not an acquittal. Here, they found it not to be true, which is an acquittal for all purposes.
Only for one count. So you're essentially stating that because they found the multiple victim allegation not true on count 4, that the other forcible sex crimes need to be dismissed?
Correct, because they said that there were not other victims. No rape occurred of other victims. That's what the multiple victims allegation states. They found that beyond a reasonable doubt and were polled as to that issue. So that is a verdict that was taken by this court and stands. There is no touching it, no readdressing it.
Brian, I thought that was a very powerful argument. I've got the motion right here. It was well researched. And even though distinctions were made from the case that was supporting the defense argument, and there was another case that was brought up, listen, this judge has the power to make precedent. The judge can actually go with the existing law and then make new law. But they lost this motion to dismiss. What were your thoughts about this?
Well, I haven't seen the motion to dismiss, but rest assured, that was filed for a reason. And I think this is important for a lot of your viewers to realize. Behind the scenes of these big trials that you're covering on court TV, there are so many documents that are filed with the court. We were filing stuff almost every day in Dalia DiPolito's retrials. Why are the lawyers doing that? They are they're preserving the record for appeal. This motion filed today, you're raising a great point, will be the cornerstone, I believe, of an appeal. You raised a good point a couple days ago. This allowing the evidence of I get lost in a 2, 3, and 4 to prove 1. I mean,
right.
To me, that seems patently unfair too. Look, I would take that up on appeal too. I don't care what the law says. Maybe an appellate court will interpret the law differently and give you a more fair shot. But at the end of the day, before Friday comes, you're going to have a lot of work to do, I think, because there's going to be other motions filed by Carlos and Watkins to try to get this conviction reversed on Jane Doe 2.
Right. Okay, so just taking again this argument for the motion to dismiss, okay? So they're basically saying even though guilt was found for Jane Doe number 2, because of this specification that says not true, that there's not more than one victim, can't the defense make an argument that this was litigated, that Jane Doe number 1 and Jane Doe number 4 were litigated, and that double jeopardy was initiated? Okay, so double jeopardy. I'm the loss for words. Double jeopardy clicked in, and therefore this cannot go to retrial. I'm just.
It can't be retried again.
I'm being a little creative here.
Yeah, they definitely. Yeah, they're definitely going to make that argument. And just so your viewers know, the double jeopardy means you can't be tried for the same crime twice. And this is a creative argument by Mr. Watkins and Mr. Carlos. And again, that's going to be one of, I think, several arguments. I would raise another one I mentioned a little earlier in your show about, I know you think it's far-fetched, but this inconsistent verdict on Jane Doe number 2. How do you find, the forcible rape, but no sodomy? But look, at the end of the day, Seema, this was a heavyweight match with really good lawyers on both sides. I had the privilege of talking to all of them for a bit outside your studio here, and these are really, really good lawyers. And there's a lot of emotion running thick in this case. Dan Owens even said that he saw on the faces of many of the jurors disappointment. And I was curious. I was like, what are they disappointed about it? The case is over. They should be happy. They're moving on with their lives, right? And he said he got the sense they were disappointed because that they didn't get verdicts on the other 8 counts. What does that tell you? Wow, this jury really did, most of these jurors really did care, about what they were doing and the job and the oath they took in this case.
I think they certainly did, and I think jurors do take it to heart when they're given a job to do, they're asked to deliberate, they're asked to come to unanimous decision, and for whatever reason that doesn't happen, there can be a sense of failure that they did not see the process of justice to its natural endpoint. With that, Brian Claypool, I want to thank you so much.
Yeah.
More Court TV Live
Thanks for
after
having
this.
me, Seema.